Yes, 4 statutes: the Assumption of Office of the President Act 2012, the National Security Council Act 2012, the Office of the Attorney General Act 2012, the National Government and Coordination Act 2013, proposed amendments. This is a public participation. There is no restriction apart from in terms of time, so that we are able to hear the others who are also queuing, and we don't keep them for too long. We notice that you do have a written memorandum, which is very kind of you, and we are most grateful for this because we shall look at it. So bearing in mind that we do have a written document, we'll give you just a little bit of time to elucidate on that document, elaborate on it slightly, so that we are able to ask you questions. So how many minutes do you need to do that?
Thank you, Chair. Thank you, members of the committees. I think we can be done in about 10 to 15 minutes max.
Give you 10 minutes, please, and then we'll ask you questions. You don't have to go to too much theory. Tell us whether you agree or you don't agree, so that we can quickly have the rationale for agreeing and the rationale for disagreeing very quickly.
Wow.
All right.
Thank you, co-chairs. I think that's well taken in. We will make the amendments reflect that, and apologies for that. So thank you, Chair, and the co-chair and the honorable members. What we have submitted in terms of a written memorandum is in response to the request by the joint committees through the clerk to make our presentations on the proposed amendment to the bill. And I would make a brief introductory remarks, and thereafter invite our head of legal to speak into the substance of the memorandum, just highlighting, because what we intend to present is already on record. So one is, of course, to appreciate the invitation to appear for purposes of looking into the bill, that is National Assembly Bill number 73 of 2023. Now, as a ministry and as a State Department, we acknowledge the speed with which this bill is being fast-tracked for purposes of addressing gaps that currently exist. And I must also admit that the Honorable Vice Chair, Honorable Mwengi Mutusi, has also had an interest in this bill for purposes of addressing the issues around representation. As you've rightly mentioned, there are 4 statutes for consideration. One is on the Assumption of the Office of the President Act 2012, the National Security Council Act 2012, the Office of the Ages Act 2012, as well as the National Government Coordination Act 2013. It's worth noting that as a ministry, we had already picked this as one of the major amendments we needed to make, and we've had a number of attempts towards that process, albeit we've not been able to have that concluded. And therefore, the proposed bill comes in at a very timely moment, in the sense that then we are able to take advantage of what we had originally proposed to change. And with your consideration, then this could be factored in as part of the bill that is in question. And in our highlights in the memorandum, we have actually picked the specific sections of provisions that we feel needs to be adjusted. So we have made proposals or recommendations to one, the statute on the assumptions of the Office of the President Act. We have done the same to the National Security Council Act, and Lastly, we've also looked at the one on the Attorney General as well as the one on the National Government Coordination Act, where we have also made the additional proposals for amendment. So, Honorable Chair, with your permission, I would want to invite Mr. Onyiso just to briefly, in the next 3 to 4 minutes, highlight, and then we can be able to take in your comments or questions.
Just before that, I think we need to resolve the issue of the additional proposed amendments which you want to introduce, and they are not part of this bill. And they are substantial, because we are prohibited from making any substantial amendments to a bill unless those amendments have been included in the bill. That's number one. Number two, this is a government bill. You guys were aware of it. Why were those proposed amendments not included here? So that we don't take the presentation on the new matters only for us to say they are misfitted. They do not fall into good place in this bill.
So, Chair, they are important to the extent that they help in clarifying what we strongly believe are critical to take care of. I'm not sure whether I would want to look at it as completely changing the structure of what the bill is, but it technically just helps in making it better. So we are not overly introducing what you would consider to be out of place with the original intention of this bill.
Why were they not included in this proposed bill? Or you are not aware of the bill?
I think, Chair, as a ministry, and part of why we have been invited to this forum is to enrich and add value. And we think that what we are bringing would add value to this exercise.
All right, thank you. I'm told, let me leave that at that. Quickly, in 4 or 5 minutes, just where you are not opposed to say we support. You don't have to give us the rationale, because we also, where you are opposing, now we want to see your rationale. In 3 or 4 minutes, please, let's hear from the legal counsel.
Thank you, Chair. Very quickly, I turn to the assumption of the Office of the President Act 2012. We are supporting this proposal. We support the expansion of the committee to include the National Security Advisor and the PS Defense. Our only proposal here is in respect to Section 5(2)(c), where we are kindly urging the committee for amendment to that section so that the Cabinet Secretary responsible for matters relating to internal security be a member of that committee, and not the Cabinet Secretary responsible for matters relating to registration of persons and immigration. We're also proposing that the chair of the committee be head of public service. And we're also proposing that the principal secretary, Constitutional Affairs, be replaced by the Solicitor General. We're also proposing that the principal secretary in charge of local government be replaced with the principal secretary, State Department for Devolution. Now, turning to Section 5(2)(r) of the Act, the bill seeks to increase the representation of the President from 3 to 6. We are supporting this proposal. It will strengthen the President-elect membership in the committee and will enable him achieve diversity in representation to that committee. I move to the National Security Council Act 2012. And one of the amendments seeks to introduce the word committee and the National Security Advisor in the definitive section of the Act. We support this amendment. And in Section 5 of the Act is also being amended. The amendment seeks to establish a committee known as the National Security Council Committee. It sets out its composition and function. It also sets out that the secretary of the committee shall be the secretary of the National Security Council. We support all these proposals. However, our point of departure is having the National Security Advisor as the secretary to both the committee and the council. We realize that the committee makes recommendation to the council, where the National Security Advisor will be sitting. Again, the National Security Advisor is the secretary to the council. In other words, he'll be sitting to make decisions over our own recommendations. We have a problem with this. And we suggest that the National Security Advisor be restricted to the council, should not be a member of the committee. The committee can co-opt him or her when they need or when circumstances arise. That is as far as the National Security Council goes. Then we go to the Office of the Attorney General's Act, 2012. The amendment in Clause 2 is in respect of Section 27 of the Act that removes the custody of the public seal from the AG to the head of public service. Again, we support that proposal. We move to the National Government Coordination Act 2013. And these acts, the amendments concerning this act are introduced the Office of the Chief Administrative Secretary and the Head of the Public Service. And we are in support of all those proposals. That is as far as my contribution to this debate is concerned. Thank you, Chair. All right.
PS Interior and your team, beginning with the assumption of office of the President. The National Security Advisor is largely an appointee of a sitting president, because we are looking at these laws in posterity. And when you are talking about assumption office, you are also talking about a president-elect. And ordinarily, there may be tension, and we have witnessed it before, between the sitting president and the president-elect. Why do you want an advisor who is like a personal staff of an outgoing president to sit in an assumption committee of an incoming president? I want to understand that rationale. Number two, because we, and you know the situation we were in just a few months ago. Number two, in terms of looking at the Office of the Attorney General Act and the Public Seal. Let's go to a company situation. We have private and we have public companies. Safaricom, many of you here also own your own companies. At a company level and even under the company's law, it is the company secretary who is the custodian of the company seal. It's not the CEO, it is not the managing director. Under our constitution, the Attorney General is given specific functions which are to advise even all government contracts that are entered by the government. The opinion comes from the Attorney General. I have looked at the Constitution, I have looked at all our statutes, over 700 of them. I have not seen anywhere in the Constitution where the Constitution created the Office of the Head of Public Service. In fact, the office in the Constitution is Secretary to Cabinet. There is no office in the Constitution called Head of Public Service. It doesn't matter who owns. We are just looking at the law because we are legislating for this country. I have not seen any act of parliament that creates a position called Head of Public Service. So why do you want to take away the public seal from a constitutionally established office when we know the practice in all the Commonwealth countries? is that the public seal is normally held by the Attorney General to an office that has been created administratively. I want to understand. Number 3, the National Security Council Act. What is the problem with the current situation as it is? Because we want to address a real problem. We don't want to create offices for people. We don't want to discuss as Parliament imaginations. Do we have a problem with the architecture of the national security architecture as it is currently? A live problem that requires legislative intervention. And tied to that, I've looked at Article 240 in terms of membership of the National Security Council. And I've also looked at the CKRC, because this is a creature of the constitution-making process. And the reason why there are certain officers have been proposed, the Inspector General of the Police, is because he leads an institution called the National Police Service. The Director General of NIS is because he leads an institution. The Cabinet Secretary for Interior is because he leads the institution that you people are. So they bring an institutional memory. They bring an institution to them. You have chiefs, you have sub-chiefs on the ground. I want to understand, what institution does this National Security Advisor bring? Because security is not a desktop issue. It's not something that you sit and you say, in school, we studied, and therefore, it is a live issue. If you want the security situation in Kibwezi, you will ask the Sub-County Security Committee, and they will tell you what is the live issue. What machinery does this National Security Advisor have to warrant sitting in that committee? I'm asking these questions in objectivity and in fairness. Chairman, you want me to finish?
That's Honorable Mutuse. Okay. Those are 3. They are pertinent.
I wanted
Number 2.
My last one, National Government Coordination Act, because there are 4. And this one I want to question it from, because this government was elected to power, and we now have what we are calling the bottom-up economic transformation agenda, which is moving from the bottom. And we have been having this discussion about village orders being part of the national security mechanism. But now we are bringing the top. We are bringing the top head of public service. We are bringing the top cabinet administrative secretaries. And while we do not have the problem with them, why didn't we find it necessary also to include wazee wa vijiji in that amendment, so that the people, the ordinary wananchi, also have something from it?
Thank you. Let's see. Honorable Mogaka was number 2.
Yes, I was, and thank you for maintaining me in number 2 co-chairs. My first comment is a general one, that I heard PS say, if I'm wrong, he can correct me, that this is the first time he's interacting and commenting about these proposed amendments. I want, in his response, to confirm that the Interior Ministry has not had occasion to give their views on these particular proposed amendments, and that this is their first instance. The second one, the specific one, is the assumption of office. At 5.2, you want your CS to replace the CS of immigration. I don't know whether we have a different CS of immigration, but you want your CS to replace somebody who deals with immigration. And we all know that during assumption of office, we have extremely many guests who come, and their immigration, their movement into and outside the country is so key if they have to make it in time for the function. Why do you want them, the immigration wing, not to participate in the most important business of assumption of office? Fast forward, because I associate myself with the Vice Chair, Jailak, I want to understand on the office of the Attorney General, and forgive our legal background, because we all know that the company seals, the corporation seals, are always the business of secretaries and lawyers. And for our purpose, the equivalent of that is the office of the Attorney General. Why are we changing all this system and move the seal away elsewhere? And then more importantly, I want to understand, if that were to happen, how would it be operationalized? Because the witness to seals usually will be the office of the Attorney General. All contracts are witnessed by the office, are drawn and witnessed by the office of the AG. So how will it be operationalized? Will the AG's office be called to come and append their witness signature on a seal already affixed on a state contract? I think I will leave it at that, Chair. Thank you.
Thank you so much, Osoro. Honorable Osoro is next. Then we had Kaunya.
Thank you very much, Honorable Chair. Honorable Chair, I may not really wish to add much because the Vice Chair has picked my mind entirely. I don't know whether we were reading from the same script, but it's really picked my mind, and I'll really be very happy if the PS gives us such answers critically. But I also want to agree with, maybe I'll just make a comment, with the PS and on the proposal, on the questions that they've raised about the advisor, which is, for me, was also an issue with me, inclusion of the advisor. But fast forward, and also the addition of the 3 people, and the president-elect. But fast forward, I need to ask this very particular question about the CAS, the inclusion of the Chief Administrative Secretary. That is the amendment on Section 12, Clause 2. Said the amendment seeks to establish the office of the Chief Administrative Secretary and their qualification, appointment, and duties. What are we seeking to achieve in this? I mean, I need not really to belabor the point, but I want to understand what we really are seeking to achieve in this whole. Are we trying to, let me not say that, let me hold it, but what are we seeking to achieve this?
Thank you, Honorable Osoro. You soon be told what we are trying to achieve. Honorable Kaunya.
Thank you, Joint Chairs. Joint Chairs have one question. The PS, Interior and National Administration. And that comes from the presentation on page 5. The second item, Section 5, Clause 2, regarding the National Security Council. Having the benefit of working in the provincial administration, there has been a traditional structure. And from the amendment, which PS, you indicate you support, it appears to me the amendment is only to introduce a secretary at the top. And I don't see anywhere in the amendment where the structure which is supposed to be replicated downwards to the regional, the county level security, and down to the sub-county level. It appears to me from the amendment, if we introduced a national security advisor, as it is now, is the secretary, and we legalize it, then you'll also need perhaps to introduce other advisors at the regional level. I am not sure whether there will be advisors to who, because the current state is the advisor to the president. So I wish you could clarify that aspect. Lastly, whether that provision is unconstitutional. From the look of it, it would appear unconstitutional. Tell this committee from your findings whether it's constitutional.
Thank you. We had Honorable Russell.
Thank you very much, co-chairs. Co-chairs, my first entry to this is we are looking at expansion particularly in the area of that transition committee. The first question I want to ask you, the last elections are very fresh in our minds. Yes, it is almost 2 years down the line, but it's very fresh in our minds. Do we have really a written report that tells us it is necessary to increase that committee by this or that designation? Because as far as I'm concerned, when we are looking at amending laws or introducing new elements into existing laws, then there must be a lacuna in the previous law. So for that reason, we really want you to tell us. On this issue of seal, you know there's the popular English saying that if it's working, don't repair. Is there a problem currently? Because the Attorney General is the Chief Legal Officer and the Chief Advisor to government on legal issues. Why do you want somebody else to take that responsibility by holding the government seal? Finally, it is on the issue of composition and functions of national government administration. I don't know if the chairman, JLAC, was referring these to as the additional. If not the additional, if it is within the proposed amendment, looking through these amendments, my concern is this is an area that requires more deliberation, more discussion. What exists currently? The interface between the president, the cabinet secretary, administration, interior, in terms of creating new administrative units. If the current system works, why do you want us to legislate? Thank you, Chair.
Honorable Farah.
It's captured very well by Honorable Metuse, and we are legislating for posterity. We are not trying to create offices through statutes or through these things just for a stopgap. So I think he's captured it very well. Thank you.
All right. I'll try to have the last bite. Oh, TJ? No. Let me ask, then you can ask. I will give you a chance so that I also don't forget what I was about to ask. Let's begin with the Office of the Attorney General, the seal. The rationale you have given is that being the administrative head of the executive office of the president, it is only logical, which means we have been illogical ever since for the last 60 years, if you've carefully thought about this. Logical that head of public service be the custodian of public seal and any instrument of state in the custody of any person. The Honorable Attorney General is the Chief Government Legal Advisor. In fact, he is the one who is mandated to hold instruments on behalf of the government, because he's the one who determines where to put the seal and where not to put the seal. The last 60 years, you should be able to tell us what we have done which is wrong, maybe we are discovering now, as a result of having the seal kept by the Office of the Attorney General. If there is nothing we have done which is wrong, then absolutely this amendment is superfluous, and it's just meant to try and change things we don't know with what motive. Number two, I don't know whether you've looked at constitutionality of the proposed amendments to the National Security Council. because the Constitution itself provides who sits there in that particular council. And you have said you support the proposed amendment, which introduces a new person, the secretary to the council, to sit and head a committee of Security Council, while the Act makes it very clear that that committee can only be committee of members of the council. So it means you are introducing a new person to sit in the committee and by extension sit in the council, and it's not one. If you look at the proposed amendment to Section 5, there are very many. Now to sit in the council through committees, would that be constitutional? Because if you say the Solicitor General sits in a committee, the National Security Council Committee or whatever you're going to call it, that committee, according to the Act, is a committee of the council. It's only members of the council who sit in those committees, and the only other foreigners who come in is through co-option. So unless you're saying we should amend this to say these are co-opted, but if they are sitting in those committees as of right, then we are through the back door extending the council to include members who are not provided for in the Constitution. I hope you've looked at this and you'll be able to answer. Thank you. Let's hear TJ, then we hear Wajir.
Chair, it was good I followed you because I just want to buttress your thinking. Let me ask a hypothetical question. First of all, you see, the Constitution says that an act will be valid, say executive order or something like that, when it is in written form by the president, number one. And two, when it is, when the seal is appended to that document. So those are two important things that make a decision or an order be legally binding and lawful and constitutional. One would not go behind it of whatever else could have arisen. Simply if a document has the president's written word and the seal, it is lawful. Now, an hypothetical situation. If the president were minded to sign an order, executive or otherwise, or create a law, create something which denies the rights of citizens in one way or the other, something that the Attorney General is adverse to, or the Attorney General has given advice against it, but just because the president's office has the seal, and of course the president also has his hand to write, he then writes, and because the seal is just next door, he appends the seal, but despite the fact that the Attorney General was adverse to it, it becomes lawful. Don't you think that it would seem that that is what the law was creating to separate or disperse the risks? You go to a bank and you find that a bank, to get into the safe, you have to get two people or more to be able to open the seal. By good advice that probably the two people may not be at the same place to open that seal. Don't you think that this could be the reason why the Constitution dispersed, the law dispersed the powers on who holds the custody and who actually does it? And two, is there a law, in my recollection, that says that the public service is the custodian? That word, custodian, does it appear in any law that then the public service is the custodian of instruments of power? That is one. Now, number two is about this changes to the assumption office, right? You say that you should have PS in charge of interior instead of PS in charge of immigration. Whatever else they are doing, did you go back to the law, the foundation that created the law, on the one that proposed the PS in charge of immigration, and find the rationale, right? Or has the rationale changed? If, for example, the immigration person was there because he would want to determine people who come from Tanzania at that particular time, or make it easy for persons that, visitors that are coming in, so that they get their travel arrangements, just in case that was the fundamental reason. Has that changed that now you require interior, and interior is internal. Now you require persons who will give you intelligence about what is happening around. Has that changed? Okay. And two, I think that already there is the cabinet secretary in charge of the cabinet secretary of interior. The proposal is just to add the PS. I may be wrong. The proposal is just to add the PS, and that is why there is the PS in charge of immigration and the PS in charge of devolution and so on. If then there is the cabinet secretary in charge of the interior, so where is the problem? Thank you.
Thank you so much, Honorable Wajir East. Bande.
Thank you, Chair. First and foremost, as clearly put by my colleagues, we don't do, or we don't legislate for the current regime. We legislate for posterity. My question is, might you be introducing offices behind the back door, especially when you talk of establishing chief administrative secretary? Does that mean the cast that we have that has been, thrown out of the window by the courts? Is that the same office? And are we bringing it through the back door? The other thing, when you say we are introducing the office of the National Security Advisor, of course this person is appointed by the outgoing president. And you are telling me here that this person is going to advise the incoming president. What kind of advice is he going to give in terms of security? Thank you.
Thank you. That is quite a mouthful now. Farah, you need. Let them answer, then we see whether there is need for any other round. That's a mouthful. I think you now need to tell us exactly what this is all about, and also tell us your participation in it. Whether you have developed the policy or you are seeing this for the very first time as we are also doing it. So why is the government speaking in different tones? One sector is supporting, another sector is opposing. Have you seen the policy on this? Have you seen the cabinet paper on this? Have you seen anything to show this went through the government, or it's whimsical?
Thank you, the honorable chairs, the members. I will attempt to respond to the questions and concerns in no particular order, just as I'm able to remember through them. So, first of all, the honorable vice chair talked about the question on the assumption of the office in terms of the advisor sitting in, and the question on the who has the custody of the public seal, and if there is anything that has gone wrong to warrant the need to make those changes. So maybe first let me speak to the fact of whether we have been privy to this proposed bill, and the answer is yes. And at some point we did write to the clerk with our recommendations, subsequent to us being asked to appear before this committee. So yes, it's not the first time we are being made aware of this. So
did you participate? Did you participate in its drafting? I mean, is there a policy on it? Number one, is there a policy on this? Is there a cabinet paper on it? Or you also saw it and then you wrote to the clerk to say, sorry, we have seen something here and we want to participate in it?
I wouldn't answer yes or no, because I would not purport to speak for the government, yes, on that particular matter. Now, there is this National Security Advisor who sits in the National Security Committee. And if you look at our memorandum, we have one, we do not have an issue with that at the National Security Committee, but then also there is a National Security Council Committee, which is a committee of the Security Council.
Just before that,
yes,
the advisor sits in the council as who? As member or secretary?
He sits as a secretary. The advisor sits as a secretary.
So that advisor is not a member?
No. And I think the proposed amendment is to be able to
make him a member or make her a member?
Yes.
Can we do that constitutionally?
I wouldn't be able to take up your responsibility as Parliament, because that is the work of Parliament. So I would want to confine myself to what my responsibilities, or what at least I'm capable of doing. Yes. Then, of course, there's a question of whether this is coming through the back door, the various positions. And I think the fact that we are having this participation and the fact that Parliament is sitting through the committees would be able to pronounce itself on whether it is something that makes sense or not. Yes, and that is the whole essence of us coming here. The Honorable Mutuse spoke about the issue of the village elders, which I know is very passionate about. And if you look at what we have submitted in the memorandum, at section 15 of the Act, clause 10, we have actually spoken to that and provided for it. So again, if the committee sees that it's good to have, then we will be more than happy. Then on the question of the membership to the assumption of office, where we are proposing that the CS in charge of internal security as opposed to the CS in charge of immigration. I think as it is today, the CS in charge of security is the same CS in charge of immigration. Yeah, so, but then we were looking at it from the point of the internal security perspective. If we are in a situation where the two roles are held by different CSS, how then do you ensure that you have full control of the security apparatus for purposes of the assumption of office? That is how we are looking at it. Then I've responded to the issue of the Chief Administrative Secretary, whether it's through the back door or not. But again, more critically, as part of supporting that, is the fact that the proposal is to help in the coordination of government functions across the executive. Then the Honorable Kaunya has asked about whether we are going to devolve the functions of the security advisor at all the other levels, given the security architecture or structure that runs across. I think I would leave that to the committee members, or the members of the two committees, to make a determination on that. That is, if you see it fit to keep that proposed amendment. Then I think I've spoken to the only thing that I think I'm missing or that I'm yet to speak to is the issue of the government seal. And again, from where we sit, we do not see any problem if that sits with the head of public service. And of course, that can only happen if it if it is done by way of legislation, which you are responsible for. Yeah.
Chair, just on that very particular one, kindly.
Honorable Solo,
Yeah. I think, PS, on the very last point that you've just finished on, the question is whether there is a crisis. Okay. Whether there is a process, right? I mean, there is a problem right now that needs to be sorted. I mean, is in the tray of the head of the public service, as currently is, very heavy, and now you are adding something on top of is part of the responsibility. What is this that is making us change that responsibility from the AG to the head of public service? You've said there is nothing wrong. We may also feel there is nothing wrong. But is there anything wrong with the current dispensation as it is, with the current position as it is? If there is nothing wrong on the movement, then there shouldn't be anything wrong, holding it as it is right now. That is my concern so far.
Chair. Those who have not spoken, Honorable Kagusha.
Yeah, thank you very much, Chair. The AG has held this seal since independence. What is this that has occasioned this move and the need now to transfer this from the AG to the head of public service? And I mean, personally, I just want to put it clearly that I would be opposed to that. I'm also wondering why is it that we want to now introduce the advisor to on security matters to be the secretary to the security committee. Again, why do we want to change from what we have been having? Is there anything fundamentally wrong with the system as it has been operating now? Because if we do transfer services, I mean, some of this authority to some of the people who are almost like partisan staff, because like an advisor is almost like a partisan staff. And the head of public service, again, is at the pleasure of the head of state. I mean, are we not concentrating all this authority now in just one area, other than spreading it, and so that it is used in the right manner at the right time? Because again, as we legislate, we have to look at the broader picture and the bigger picture.
Thank you. Let's hear from my co-chair, Honorable Tongoyo, has something to say. Then we finish the responses. The truth is, we may not agree on this. Some of it we shall do it when we...
Okay.
Let's hear Tongoyo first.
Thank you so much, my co-chair. I think mine is just very brief because a lot have been said, and of course I'll attempt to try to respond to them. I think on the issue of national advisor, I cannot be able to say it any better. The Constitution is very clear, and it stipulates the membership. And even on the issue of maybe assigned to be in the committee, we were here with NIS, and they demonstrated the several number of committees. So actually, I don't even know now which committee he can able to be the secretary, because the committees are several. Now, more importantly, there is the issue, of course, on our National Government Administration Amendment Bill. What was actually published and read in the House in this bill, you introduced the other aspect amendment to do with administrative units, which is a very popular thing among the politicians. The issue of village elders and all that, you know it. And of course, my brother here is very passionate about it. But I've got a concern, of course, that it was not captured in the bill. It was not. So it's not properly actually before us here. Because our standing orders are very clear on how the bills are brought forward. If we read our standing order, number 133.5, on how the bills are introduced, procedure in the committee on the issue of the bills, then it says, no amendment shall be permitted to be moved if the amendment deals with a different subject or proposes to unreasonably or unduly expand the subject of the bill, or is not appropriate or is not in logical sequence to the subject matter of the bill. So the bill actually on the national administration was largely on the issue of cars, the issue of the head of civil service, and the issue, I think that's largely the issue. So I want to say, we know you're a country that is very democratic. And we don't want the issue where we do something, someone rush to the court, it was not procedurally done. So I will suggest maybe this one, we reintroduce in a procedural manner, either as a committee bill or still through the lead of majority, so that we don't run into the challenges of them being challenged in courts.
Can I say something, Chair?
I'm just finishing.
Let him finish.
Of course, I had an opportunity to go the proposal, which I had found it a little bit even making it more complex, because I found there is now a provision where the president has to approve. Normally, we know how we do it. We do it from the sub-county levels through the security committee, county, then comes up. Of course, the cabinet secretary approves through gazettement. That's how we operationalize and create the units. But as it is, which I don't want to deal so much because, of course, I have an issue on a procedure, we'll deal when we get there. So thank you.
Thank you. Lisa? What you do is, let's hear Lisa, then he'll respond. We'll retreat as a committee now and do the actual debate. Okay. So that we arrive at, because we may debate too.
Okay, thank you, Chair. The committee.
All right, let's hear Lisa first.
Thank you, Chair. I want to speak about Section 15, Clause 10, where it's speaking about the structures. And as the PS was speaking about the appointment of different officers, and they started from regional commissioner down. But I don't know why many senior officers are very ashamed to speak about a village. Behind you, Bwana PS, you can look behind you. There's a village there which was not actually meant purposely for this presentation. But I want to think that, that is a village. And this is where we are coming from, all of us. But we are in cities. We are ashamed to mention about it. I was really happy and I was expecting him to speak about the village elders and Nyumba Kumi. Thank you.
Honorable Farah, you are the last one. All right, let's have Honorable Farah. I'll stop him halfway, then I will hear Kajwa.
Yeah, Chair, there are three things here. One, of course, we are legislating for posterity. We are not legislating as a stopgap. And the issue of the advisor, that I think has been put to rest. We can only have a substantive officer in a position like that, and that has got to come from the committee itself. On the issue of exchanging the PS in what they call immigration and the PS internal security, Chair, over 95% of the problems in a country are internal. You hardly get a country invading you from outside. In a situation like this, when there's a transition, I have absolutely no problem with swapping those two and getting the PS internal security being a member of that transition authority or the transition team. And I think that's very fair. On the issue of the seal essentially is the government, is the president of the country, in a sense. And I do understand that we had this thing under the custody of the Attorney General way back when the Attorney General had a security of tenure. He didn't have to run for elections. Number two, there were a lot of roles. He was also Director of Public Prosecutions. A lot of those roles of the Attorney General, which were hitherto there, now have been dispersed. The Attorney General no longer enjoys the security of tenure. A lot of work has gone to the Director of Public Prosecution, and then Solicitor General has also hived away a lot. He's basically no more than an advisor to the government of the day, and the government is the president. So I think what you need to do is that go back and make a serious case for this. I wouldn't have a problem if you make a very serious case by somebody like the head of civil service being the custodian of this, but of course you present it better than you have done now. So I'm looking at these three in that fashion. Thank you.
Honorable TJ, you are the last one. Then after that, we take the summaries of
I
that.
wouldn't take long.
Yes.
You know, PS, there is something that we are passionate about as members of the legislature, the point of how we make legislation. And how we make legislation is that we would wish that there is a policy document that can be referred to both academically and in terms of reality. Or there is a cabinet paper. This is what Chair put to you. You are a PhD holder, a scientist. So for the sake of intellectual honesty, would you state, in any case, you are the PS for the interior, if there is a policy, you would know. If there is a cabinet paper, you would know. For intellectual honesty, would you state that there is a policy paper, a cabinet paper, or not? Simple, clean, and square.
I think let's hear some responses to that. If it is not there, just say it's not there or you are not aware. Don't worry about the ferocity. Yes.
Honorable Chair, thank you, Co-Chair and the members. So first of all, with a lot of respect to Honorable TJ, I don't sit in the cabinet, so it will be preposterous for me to speak to matters that are discussed at the cabinet. But then I want to believe that as part of the process of legislation, which we must all adhere to, that everything that then comes before Parliament and the committee must meet those requirements, and any that doesn't then does not deserve the time of this honorable committee to sit and hear. Then to Honorable Chelule, the issue of the village elders, it's at the core of our operations as a government, and that is why we thought that it's important that we speak to it as part of the amendment, even though it might have not come out as pronounced as you'd want, but it's something that is very significant in the architecture of not just governance, but also representation. And I want to follow through the comments from Honorable Tongoyo, the chair of Security Committee, that in a way we are actually not unduly expanding the subject matter because it touches on national government coordination. Yeah. And just not necessarily for records purposes, is that we have a good opportunity to resolve this matter without undue delay, because Honorable Mutuse has been on it. We began that process, and it will be good if we could get it sorted out. Thank you, Chair.
Thank you so much. I think that covers your
More radio, 88.2 FM. We are in charge.